Right, I'll start the meeting. Firstly, can I convey my apologies for the technical gremlins this morning? Right, welcome to the Licensing Subcommittee meeting of the 22nd of June 2023. The first item on this morning's agenda is the election of chairman. Can I have nominations for the election of chairman, please, members?
Can I propose Councillor Flagg, please?
I second Councillor Flagg.
Thank you, members. May I refer to our clerk this morning just to run us through the housekeeping measures. Mr. Fraser.
Thank you, Chairman. And again, apologies for the technical issue this morning. Hopefully, it's now resolved as best we can. So, formal hybrid meetings of the Licence Subcommittee. Please note that this meeting of the Licence Subcommittee is being recorded by the Council. It won't be for live broadcast. It will be updated to the website following this meeting. It'll be published on the Council website for a minimum of 6 months. In order to ensure the meeting is managed effectively, please could everyone present follow these ground rules for speaking. Only speak when invited by the Chairman. State your name before you speak if you have not been introduced by name. If joining remotely, please ensure that you unmute yourself and always turn on the video function before speaking. Mute your microphone when you are not talking. After each party has made their representation, the Chairman will ask each person in turn if they have any questions or comments. However, if at any point you would like to speak again, please use the raise your hand function at the top right of the screen. For those in the room, please note that if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point along Brady Road under the flyover. Finally, if joining remotely, please ensure background noise is kept to a minimum, and can everyone ensure that mobile phones and other devices are turned off or switched to silent for the duration of the meeting. Thank you.
Thank you. Can I ask if there's any apologies to record this morning?
No apologies, Chairman.
Thank you. I'd like to ask the legal representative who's joined us this morning, that's Mrs. Cole, just to clarify a couple of issues for this meeting.
Good morning, everybody. I just wanted to have a quick word about declarations before they're made by the subcommittee today. We are aware that one of the objectors to the application today has been lobbying the wider licensing committee about this application. We were made aware of it a couple of weeks ago. My advice to that licensing committee and members that have asked me, and particularly to the members that are on this subcommittee today, that they had to ignore any information that come from that objector apart from the official written objection to the application which they have got. They are aware of that, and I have asked them that they are able to put that to the back of their mind, and they've assured me that they are. So I'll ask them now to give their own declarations.
Thank you, Mr. Cole. Councillor Sandra Moore, please. Declaration of interest.
Yeah, thank you, Chair. Yes, I have received email objections, but I haven't responded to any of them. Thank you.
Thank you. Councillor Keddy.
I have also received email objections, but I also have not responded to them.
Thank you. And just for confirmation, just to confirm that I indeed situated at 159 Old Christchurch Road, Bournemouth, to permit relevant entertainment to continue for a further 12-month period. The licensing authority has received 2 valid objections. This matter is brought before the licensing subcommittee for determination. I will now ask each participant to introduce themselves and state their role. I am Councillor David Flagg, and I'm the elected chairman of and a member of the subcommittee for this morning's meeting. Councillor Keddy, please.
My name is Councillor Keddy. I am an elected member of BCP Council and member of this morning's subcommittee.
Thank you. Councillor Moore, please.
Yeah, Councillor Sandra Moore. I'm a member of BCP Council, represent Campert's Ward, and I'm a member of the subcommittee for this morning's meeting.
Thank you. Councillor Chris Matthews and Councillor Adrian Chapman-Law were the reserve members. They are not required to participate this morning, but we do have a number of councillors who have joined the meeting for training purposes only. They will not participate in any deliberations that the subcommittee makes. Can I ask Sarah Rogers, please?
Yes, good morning. Sarah Rogers, Senior Licensing Officer, BCP Council.
Thank you. Mrs. Linda Cole?
Good morning. I'm Linda Cole, Legal Advisor to the subcommittee this morning.
Thank you. Neil Fraser?
Yes, I'm Neil Fraser, Deputy Head Democratic Services, and I'm clerk in today's meeting.
Thank you. For the applicant, I have Mr. John Walsgrove. Could you introduce yourself, please, Mr. Walsgrove?
Good morning, councillors. Yes, John Walsgrove, and I'm a solicitor for the applicant.
Thank you. And I also have on my list Mr. Paul Ojala, is it, if I pronounce that correctly?
Yep, that's it. Hello, yes, good morning. My full name is Jaspal Ojala, known as Paul, and I'm the MD of Wellhog.
Thank you very much.
Yeah. And very quickly, I'm Taran Ojala, the General Manager for Wiggle Club. So I oversee the group ride operations for all of our clubs.
Thank you very much. Councillor Lisa Northover, please.
Hello, I'm Councillor Lisa Northover. I'm a councillor for Mutcliffe and Stratton Park.
Thank you. I also have Miss Susan Stockwell, who I believe is with us this morning. Miss Stockwell, would you be kind enough to join us at the table, please? Probably here. Yeah. Anywhere there. You press the right-hand button.
I'm Susan Stockwell, and I'm objecting to this application.
Thank you. Before I run through the procedure, please may I check that all persons who have given notice of their intention to speak have been identified, and any person who wishes to withdraw a representation or wishes not to speak has been identified. If there are no comments, I will take this as correct. Thank you. I will now explain the proposed procedure and order of speaking for the hearing as follows. The licensing officer will present the report. The applicant will make their application. Questions of the applicant by all parties, members of the committee, subcommittee to go first. Responsible authorities and other persons will make their representations. Questions of the responsible authorities and other persons, members of the committee, subcommittee to go first. All parties will be given an opportunity to sum up, with the party who spoke last to go first. The hearing will then conclude. The subcommittee will deliberate in private with the legal advisor and clerk present. Notification of the subcommittee's decision will be given within the period of 5 working days, beginning with the day of the last day on which the hearing was held. This is in accordance with the regulations. The notification of decision will include information about the right of appeal as appropriate. I will now ask all parties to confirm agreement on the proposed procedure or make representations. Mr. Walsgrove?
Quite happy, thank you, sir.
Thank you. Paul Ojala?
Very happy, thank you.
Thank you. Councillor Northover?
Yes, I'm happy, thank you.
Thank you. Miss Stockwell?
Yes, I'm happy, thank you.
Thank you. Sarah Rogers?
Yes, thank you.
Linda Cole?
Yes, thank you, Chair.
Finally, please may I remind all parties speaking not to repeat the information which they have already given in writing, but to expand on their written representations. All questions are to be asked through the chairman, and there will be no cross-examination of parties. I will now ask the licensing officer to present the report. Sarah, please.
Thank you. Application is made by Well Hot Limited for the renewal of the sex establishment licence held at 159 Old Christchurch Road for a further 12-month period. The premises have been operating as an adult lap dancing club for the past 17 years, since they took over in 2006, when at that time the premises were operating as a cabaret restaurant. They've had the benefit of a sexual entertainment venue licence, which permits the live performance of nudity, following new legislation which came into effect in April 2010. The application made complies with the relevant legislation, and the necessary site and newspaper notices were published in accordance with that legislation. As a result, 2 objections were received. Reference is made in the conditions attached to the current licence of required policies and codes of conduct. They are ongoing policies of which we have received copies and are satisfied with them. No objections were received from any responsible authorities as identified under the Licensing Act, who were also consulted. You may be aware of recent applications for minor variation to both the premises licence and the sexual entertainment licence. This was to primarily address the concerns raised over toilet facilities, and the plans have been approved through this process to reconfigure the toilet accommodation and the VIP booths. The request with that application to remove additional conditions from the sexual entertainment licence was withdrawn, save for the additional condition 16, which was redundant in any event. These were separate applications to this renewal. Thank you.
Thank you, Sarah. Can I ask Mr. Walgrove, please, if you would be kind enough to address the committee? Thank you.
Thank you, Chair. I'll try and be as brief as I can, and in addressing you, we'll mention really 3 things. First of all, just a brief look at the legal position and what it is you're being required to consider in terms of the grounds that you may determine the application on. Secondly, to go through the merits of our application and put forward the reasons why, on behalf of Mr. Ojala, we think the licence should be renewed. And then lastly, to just run through a few comments on those written representations that have been received against the application. So turning to the first of those 3 points of submission, the grounds on which you may choose to either grant or refuse this application, you're well aware from the report that there are both mandatory grounds and discretionary grounds on which you can refuse a renewal. You can dispel from your mind straight away any of the mandatory grounds because none of those apply and none of those have been raised in the letters of objection. So the only thing you need to consider is what, if any, of the discretionary grounds apply in this case. So in terms of the objection, the first ground is that the applicant is unsuitable, and so that is something on which you are being required to determine today. So I'll come back to that in a moment when I address the merits as to why we say the applicant is entirely suitable. But that is definitely one area that you need to make a decision on today. The second discretionary ground is that the business is carried on for the benefit of someone other than the applicant. That ground does not apply. You don't need to determine that. It's not being raised by either objector. You've heard this applicant has run the premises for 17 years and all of the financial benefit is for him and no other person. So you don't need to consider that. The third discretionary ground is that the number of sexual entertainment venues would be equal to or exceed the number that the local authority considers appropriate. Again, that is not a ground which you need to think about this morning. You did have a policy in place and the High Court determined that that policy wasn't valid, and so you don't have a policy currently which determines the appropriate number, so you don't need to consider whether that ground applies or not. And then the last one, which is probably the key one to which your minds will turn this morning, is whether the renewal will be inappropriate due to either the character of the locality the use of the premises in the vicinity of Wiggle, or the layout, character and condition of the Wiggle premises. So those are, in effect, the things that you'll need to consider. Is Mr. Osler and his company a suitable applicant? And then is Wiggle at this location inappropriate because of the character of the locality, the use of any other premises within the locality, and the actual condition, layout and condition of Wiggle itself? So let me turn to the merits. That was just a brief overview of the legal position. The merits, the suitability of the applicant. So you heard from Ms. Rogers that Mr. Odger has had this premises since 2006, and the legislation changed in 2010 where he was required to have a sexual entertainment venue licence, for which he was granted one by this authority and has applied for it to be renewed every year thereafter for the last 13 years. So he's been at this venue 17 years. No one has ever questioned his suitability until today. It's the first time in all of those renewals that anyone has said he's not suitable. And in addition to that, he does in fact operate 4 other sexual entertainment venue licensed premises, 2 in Portsmouth, 1 in Southampton and 1 in Weymouth. And in all of those, which he has operated, the ones in Portsmouth for over 20 years, the others in Southampton and Weymouth for a lesser period, but still a substantial number of years, no one has ever questioned his suitability as an applicant every time he renews those. So in combination of those 5 premises, he's probably had to renew sexual entertainment venue licenses something like 45 times in the last 10 or 15 years. And as I say, no one's ever questioned his suitability. So I ask you to attach weight to his considerable experience in running several premises where no one has ever criticised his suitability. He's never been refused a renewal of any of his sexual entertainment venue licenses. And as I say, I would ask you to attach considerable weight to that. The second and probably more significant area of dispute is over whether Wiggle is placed in a locality which would be inappropriate for a sexual entertainment venue licence, either because of the nature and character of other premises within that locality, or because of its own layout, character and condition. But you will probably know from your local knowledge that Wiggle itself is placed in what we would say is an ideal place within the centre, because it's in the heart of the commercial nighttime economy. And of course, Wiggle is only open at night. It's not open during the day. And we say it is, in fact, an entirely appropriate place for a sexual entertainment venue licence to exist. And further, that there hasn't been any change, we say, in the character of the use of the premises within the vicinity of Wiggle. It very much remains within the nighttime economy. Certainly since 2010, when the first licence was granted, I'm not suggesting there hasn't been any changes whatsoever, but certainly from the last renewal from 12 months ago, we say there hasn't been any change in the nature and character of the locality or the nature of the use of the premises within the vicinity of Wiggle. And given that, we ask you to attach weight to that fact, that there have been no changes in circumstances where one could pinpoint the operation of Wiggle would have directly an adverse impact on the local community or the uses of the premises in that locality. Further, more significantly, we say that there isn't any evidence before you that would suggest that Wiggle is contributing towards the crime stats of antisocial behaviour, or the allegation that the number of sexual assaults or sexual crimes has increased as a result of Wiggle. That's just simply not the case. And had there been any concerns around whether this club caused those sorts of issues in that local community, the police would definitely have objected to the renewal of the application. And so I ask you to attach weight to the fact that they haven't. They are, in Licensing Act terms, considered to be the experts in the area of crime and disorder. I appreciate there's no similar analogy under the sexual entertainment licensing legislation, but nonetheless, I think you should sensibly attach weight to the fact that the police have not raised concerns with you that this club causes any problem locally. Just in terms of the layout and character of the premises, obviously an issue was raised last year and was raised again this year concerning the location of the female WCs. And so Mr. Odgler decided that he would change the layout of the premises, not because he thought there was any risk to women using those facilities in his premises, because they've been like that for so many years without any problems whatsoever. But he just thought it was a concern raised by the objectors. He would deal with it by having that change to where they were located to make sure they are entirely separate, and that what he considered perhaps was the only legitimate concern raised in objections last year and this year would no longer be a concern for this committee. So two things: one, he's changed the premises and made it better and addressed the concerns of the objectors, which he didn't, as I say, agree with in any event. But B, last year, this committee, who heard an application for renewal, did not consider the character of the premises was unsuitable because of the layout of the toilets in any event. So it was surprising to see that objection raised again, even though the committee had made its determination 12 months ago and would have no reason to reach any different conclusion this year than it did last year. So that's the matters I'd wish to put forward on behalf of Mr. Odgler to support his application, both in terms of his suitability of an applicant and the suitability of the premises. And so lastly, I said I would address some comments towards the representations that have been made against the application, and there are 5 points I wish to make in that regard, and they principally relate to whoever it is that has penned objection number 2 in your agenda pack. So the first point is that that person who's made that objection has made a number of statements within it which are completely untrue and are extremely misleading. I would ask you to be very slow in attaching any weight to anything they have said, unless they are going to be producing some credible evidence this morning that those facts that they state are indeed true. Of course, you as an experienced committee will know that the fact that someone says something doesn't necessarily make it true. You have to analyse what's been said and on what basis it's being said. Is there any other supporting evidence? Is there any corroboration from any other witnesses? And in particular, in relation to the allegations around crime and disorder, what have the police said about that? Is there any support for them about concerns of crime and disorder? The one thing I want to highlight, which we know absolutely is certain to be untrue, is everything that's written in relation to the HMO regarding the suitability of the applicant. So the facts set out in that objection are wholly inaccurate. I don't know where they would have found those details, but simply they're not true. It is true that Mr. Odgler was fined, his company was fined for having a house with multiple occupation without a licence. It followed an inspection to a property of his where the local authority advised him that an HMO licence was required, which was applied for within 2 days of that visit, and works were required to be completed, which were completed again within 2 days of that visit. He wasn't fined because the premises was dangerous. He unfortunately was relying on advice from a property agent regarding whether a licence was required or not. So he relied on professional advice, which is why when he was given the civil penalty for not having a licence, he appealed against the decision. Subsequently, having taken better advice, he withdrew that appeal, and so the original civil penalty for not having an HMO was imposed. So there was no increase in the fine, there was no finding that the premises were dangerous, and so all that is said in that objection is untrue. And that is just one example of what that objector has written in their objection, which we know to be false. What I would do, and I do so for the benefit of that person, is just warn them that legal proceedings are not privileged in terms of what is said in your representation. So comments about the applicant and putting forward false information can amount to defamation. So unless you are able to support any allegations with credible evidence, I do warn you before you speak this morning that if you continue to press with false information and misleading information, then it is possible that proceedings, could follow, because there are some serious allegations in there which simply aren't true. The second part about that objection is case law is mentioned. What case that is, we don't know. It's not been stated as to what it is, and a copy of that case has not been produced. I'm afraid I can't work out from the references which case it is referring to. So no doubt when we hear from the objector, the name of the case and a copy of it will be produced, and then I can properly address you on the law. Certainly in relation to the reference to case law, my view is that they have not given you a clear indication of what that particular case says. And certainly, I think it's the fourth paragraph down in the letter from objector number 2. I don't understand where the information contained in that paragraph is contained within any ratio of a High Court case with, relating to an SEV license. Obviously, I'm aware of all of the SEV licensing cases. So if an objector wants to rely on case law, they need to say what the case is, and they need to be clear on what they think that case is so that the applicant can address that. So again, in relation to any point about case law, unless that's made clearer, you should attach no weight to those comments. Third point is they appear to be giving expert opinion evidence on pheromones. Again, you'll need to ask the objector about their expertise, because as I say, when you give an opinion which expresses to be that of an expert, you need to prove your qualifications and why you should be considered an expert in that. So we'll no doubt hear what their expertise is, and you'll have to make a judgment about that. But what I would say about that principally is it's all based on the premise that the performers at Wiggle are fearful, which implies that there is some perhaps duress that they are working at these particular premises, where nothing could be further from the truth. The performers that are working at not just Wiggle in Bournemouth, but the other premises that Mr. Odgler runs, they are entirely happy with the work that they are doing. They really enjoy working for him because he runs such fantastic establishments, which are in any event heavily regulated, but he always makes sure that he and his management staff go the extra mile to make sure that the performers feel perfectly safe, not just when they're performing in the premises, but also on their journeys to and from the workplace. He takes great care to ensure that they're looked after. So the suggestion that the pheromones are going to lead to people who have attended those premises then committing assaults when they get home to their partners, again, I would say you can attach no weight to that as an argument why you should refuse to renew this licence. Fourthly, I've briefly mentioned the fact that the police have not objected to this. So the suggestion in that objection that there's been an increase in crime and sexual crimes in the area is not supported by the police. And so I would ask you to find that that is certainly not the case, that Wiggle has not seen any increase as a direct result of it operating in the local area. There just simply isn't the evidence, and making generalised statements in a representation is not good enough in my submission. And then lastly, the point made in that representation about the number of what would be described as sort of sensitive premises, because of course you have to assess the impact of wiggle on the locality. Just reading off a number of sensitive premises isn't enough. An objector would need to show what detrimental impact wiggle had on those sensitive premises, which, as I said, there's been no change in the character of the locality. All of the premises which have been mentioned have been there for a number of years, and it would be easy, in my view, that if wiggle was having such a detrimental effect on premises like schools, etc., it would be easy to prove that detrimental effect. So just reading off a list of sensitive premises which might be effective is not good enough. It needs to be shown this is the impact that wiggle has on those particular premises. And we say that there is none. It's a premises which is open late at night in the nighttime economy, and this is in a position which is entirely suitable for this type of venue, and Mr. Odgler runs this venue extremely well, evidenced, we say, by the fact that none of the responsible authorities have objected to the application. So on that basis, we do ask you to renew his sexual entertainment venue licence for a further 12 months. And obviously either myself or Paul, more than happy to answer any questions that you have. So thank you for taking the time to listen to me. I did say I was going to be brief. I think possibly in the end I wasn't, so apologies for that. But I'll leave the representations there.
Thank you, Mr. Walgrove. I will now ask members of the committee if they have any questions for Mr. Walgrove. Councillor Moore.
Yeah, thank you, Chair. We've heard that the business has been managed by the same person for the past 17 years. That's a good amount of time. And can you just confirm to me that he is going to continue to manage the business after the hearing? I've got another clarification as well, if that's okay, Chairman. Concerns were also raised about the toilets. Can you confirm that the toilets are checked, as they should be, every 30 minutes and the records kept, retained and available for inspection? And can you also confirm that you're carrying out the statutory twice weekly drug swab tests on the premises, to include the dancers' changing facilities and toilets, and are records kept, retained and available to inspect? Thank you.
Thank you, Councillor. Mr. Walgrove.
Yeah, just taking those in turn. So Paul himself, yes, he is responsible for each of his premises. When there was mention about the renewal in 2013 and the comment that was made around his management of the premises. So what his usual operation is to have a manager at each of the premises who run those businesses on a day-to-day basis, with Mr. Odgler Senior then having sort of oversight effectively as an area manager, if you like. So, but regularly visiting those premises a couple of times a week. Because of the issues in 2013, where unfortunately the manager let him down very badly by breaching some of the licence conditions. So Mr. Odgler, at that time when the renewal was opposed by the police and local authority, he undertook to make sure he managed the premises on a day-to-day basis to ensure that the things that had happened over the course of a few months before the renewal would not happen again. And that's what he did. So back in 2013, for a number of years, he had day-to-day management responsibilities of those premises. The situation has obviously changed 10 years on, where he doesn't see the need to be there every single day of every single week. And so what I can't say is that, you know, if the police or local authority turned up to inspect the premises, he's going to be there. He will certainly still have a lot of hands-on management control. But not only that, he's now brought his son, who introduced himself to you as the operations director. His son is now in the business, and he too has that site over the 5 premises. So the 2 of them now have that control, as well as having at each of the 5 premises an experienced manager to handle the day-to-day management. So there is quite a pyramid structure of management to make sure conditions are complied with. So in relation to the next point, yes, I can confirm that conditions are complied with. There were and have been some issues and discussions with the police over the drug swabbing to find appropriate products that produce, the right sort of results. Because of course, even the tiniest of traces can be picked up on swabs. So those tests are available, and the police and results are available. And as I say, my client has been in discussion with them. And initially, his application to vary was looking to consider whether that condition needed to remain because of these discussions. And in the end, the police said, no, look, we haven't got any problems or concerns that we think drugs are an issue at your premises, but we do want these to continue. And so Mr. Osler withdrew that part of the application, which then leaves the last question about the ladies' toilets, which, yes, that was the principal part of the application, to move them so that they are entirely separate. And yes, those toilet checks are carried out regularly and the records kept.
Thank you, Mr. Wargrove. Did you have any further questions, Councillor Moore?
Yeah, if I could just quickly ask, have 2 mystery shopper visits been carried out? And if so, was all in order? Were there any issues recorded? Thank you.
Mr. Wargrove?
Sorry, I pressed the wrong button. I turned off my camera, not the mute. Yeah, they have, and the results of those tests, I think my client emailed those recently to Sarah Rogers. So yes, everything was in order as far as I'm aware.
Thank you. Councillor Keddy, do you have any questions for Mr. Wargrove?
Yes, Chair. Thank you. Mr. Wargrove, I was noting the special conditions for SEVs included as an annex in the application, referring to advertising, premises, appearance and layout. I'll give a moment just to catch up. So specifically, my question is twofold. On option 19, could you confirm that there is no canvassing or touting for business in any area outside the premises in the town centre?
Yeah, that's right.
Okay, so at no point does anyone venture out and offer flyering, bill posters or any person-to-person engagement?
No, they don't. And obviously that is something on which the staff are advised that they must not do. So if there has ever been any incident of that happening, then the staff, are advised that that's not something which they should do or should be doing. But yeah, that's right. And that is a condition at all of the premises that he's got. So it's not just in Bournemouth. So that is something which is a standard throughout all of his premises.
Okay, thank you. Item 20 and 21 under the same measure, advertising, premises, appearance and layout, are stating that the council shall not permit the display of any form of imagery or photographs that the council believes could be construed as offensive to public decency. No display or advertisement of the activities permitted by the sex establishment shall be exhibited so as to be visible from the outside of the premises. I noted on walking past the premises yesterday, the logo consists of a naked woman on a pole, and it is displayed prominently for any passers-by, including vulnerable people and children, to see. could you tell me how that logo doesn't contravene those items 20 and 21, and how it contributes to the requirements of the Equality Act to promote positive relationships?
That has been the logo of the premises for several years, and not just at that premises, but his other premises, which are called Wiggle, also have that logo. So in effect, it has been previously approved not only by your local authority, but other local authorities. If that were a sticking point in your decision, that you felt that was entirely appropriate and did not comply with that condition, then obviously you could renew the license and instruct him that that isn't an appropriate sign that he should have. But as I say, it has been there for many years. We don't consider that being that silhouette, it has a negative impact in the way that you suggest that it may have in terms of equality, etc., etc. People know that the venue is a sexual entertainment venue. It's only open late at night. I get the point that obviously people walk past those premises during the day, but our view is that the silhouette figure is not one which breaches that duty of equality, nor is it in any way, we say, obscene. And as I say, it has been accepted as suitable for a number of years by different councils. But if you said it's, you know, that was the deciding factor as to whether this premises was, you know, suitable, then obviously you would have the power to say, no, you can't have that sign outside.
Thank you for your response. There was another note I made during your earlier representation, that there hasn't been any change in the character of the locality. The original license was granted 17 years ago. I would submit that there has been a significant change in the character of the immediate vicinity. In terms of, in particular, we now have a school, the Livingston Academy, within a very short distance of the establishment. And in the past 17 years, the housed student population attending AUB and Bournemouth University in that area, Lansdowne in particular, has more than trebled in that time, including the numbers of young female students living in that area who would be readily exposed to this venue from doing simple day-to-day activities. I would also mention that when I walked past yesterday, the exterior condition of the premises was left a lot to be desired. There was rubbish both on and around the premises. There was overgrowth of vegetation. The bricked disability access was overgrown with moss and looked like it hadn't received care in a significant amount of time. It did not promote the exterior view of being a neat, tidy, well-run establishment.
Just answering your point then in relation to change of locality, I think I did say, yes, of course, the license has been there for 17 years, and I did say the locality has changed. I think the point I was making was that it hasn't changed whereby Wiggle has become a detriment to those premises which have changed. In the context of this is right in the heart of the nighttime economy and is a premises which is only open late at night. So all of the late venue bars, cafes, restaurants, which are all the way along that road and used by the very people that you've said are moving into the area, the students, etc., etc. That is where those sorts of changes to the locality haven't shifted away from the very fact that this is the heart of Bournemouth's nighttime economy, and this is a suitable place for a sexual entertainment venue licence to be positioned. And adding weight to that, all of those changes which you mentioned, from the last 12 months, there haven't been any significant changes. So at the renewal last year, we actually provided evidence to the subcommittee at that hearing in terms of what developments and planning applications have been made within the previous 12 months, and there had been very, very few indeed. So all of the newer student accommodation have been there, and the school that you've mentioned, they have been there for years, as opposed to within the last 12 months since the last renewal. And that's what I was asking you to attach weight to. Also making the point that if this premises, where the location has changed over those 17 years, if it was having a detrimental impact on people's lives and that local community, the people who are making objections, which generally is only 1 or 2 people each year write an objection, you would think if it was having a detrimental effect, there would be a lot more people making representations, particularly, as you say, if you think that young women, young students might feel vulnerable because of this club being there. You would think there would be a lot more representations coming in. The fact of the matter is that women go to this venue as well as men. Young students come to this venue. It is a venue where, in fact, you may not believe this to be true, but it is, that the women actually feel entirely safe because it is so well regulated and there are sufficient numbers of staff and security, and CCTV is absolutely everywhere. So it's actually got more safeguards than some of the nightclub premises where, in fact, they may feel slightly more vulnerable. So that sort of deals with that point. And as for the aesthetics of the outside of the building, I'm sure Mr. Odgler will take your comments on board, and certainly the inside of the premises is perfectly suitable, and if there is some work to be done on the aesthetics of the outside, I don't know, I haven't seen it myself, then I'm sure he can address those from what you've described. I mean, look, I would just address the issue of the rubbish. It is unfortunate its location. It's not some of the, and there is reference to nitrous oxide, for example. That's not stuff that's coming from Wiggle. That is being dumped by other people. And certainly litter, you see, because it is a nighttime establishment, if people, once it's closed, if people are depositing litter there, of course it's not cleared in the morning because people aren't there. They don't start work until later in the afternoon. So that is the issue of litter around the site, unfortunately, is one which is not being created by the premises, but it's also not one which they address until people start working, which is sort of late in the afternoon. And it would be unreasonable, I think, to expect someone to turn up first thing in the morning and pick up other people's rubbish that they've left there. But certainly take on board your comments around the moss and those sorts of issues, which clearly would need to be addressed. And Mr. Odgler, I'm sure, is in the process of doing so. He's, as I said, he's just refurbished those toilets and some of the inside, and so we'll no doubt move on to the outside and tidy that up as well.
Thank you, Mr. Walgrove. Do you have any further questions, Councillor Keddy?
I would just like to close with, sorry, pardon me. I'd just like to close with, I did a litter pick in my community this morning to clear up a whole alleyway of rubbish. It took 10 minutes and was very straightforward between dropping the kids off at school and going to work. I'm quite happy in a non-commercial sense to keep my neighbourhood clean and tidy. I don't think it's unreasonable to expect the same from a commercial premises. I would also contend that the assessment that nothing has changed in the last 12 months is not accurate. That area is not a static environment. The Livingston Academy only opened, I don't have the firm date, but it is within the realms of the last 12 to 18 months. And each year they are bringing on new year groups and students between the ages of 11 and 18. Equally fluid is the student population, which is still increasing year on year. I would close that. Our town is changing, the area is changing, and the population is changing. Thank you for your time.
Thank you.
I just need to respond to that, because that was a statement rather than a question, but I think I should be allowed to respond to that. That in terms of the Livingston Academy, if there were concerns that this premises was having a negative impact on the students of the Livingston Academy, then those responsible for running that academy would be objecting to the application. So I ask you to attach weight to the fact that there haven't been concerns raised either by the university for their student accommodation or that school. And it may be changing in terms of, as I say, that the population, and I haven't suggested that it isn't, but this is still the heart of the nighttime economy. And if the local authority start to close down effectively nighttime economy places and the existing sexual entertainment venue licenses, it's a bold move to say that should be the case without credible evidence to say it's having a negative impact, where we're saying actually the premises has its place within the nighttime economy, is a perfectly safe place. There isn't any crime happening as a result of the premises being in this location. The police don't raise any concerns. Your own council officers don't raise any concerns. So as I said, just saying there are premises which are identified as being sensitive, they're only sensitive if they're having a detrimental impact. And there isn't any evidence to say that they are.
Thank you, Mr. Walgrove. I think your points were made well in your presentation to the committee. I don't have any further questions. I do have a question for the licensing officer on the back of one of the questions asked by Councillor Keddy, which was in relation to advertising and touting for business. Sarah, can I ask, has the authority received any complaints at all regarding this issue?
No.
Thank you, Sarah. I'd just like to address the committee. Mr. Odler, whilst he's with us on the Teams meeting, he did say that he didn't wish to speak, but I'm going to ask my fellow members whether they are happy for me to give him the opportunity to address the committee. Are you happy that I ask Mr. Odler if he wishes to address the committee? Okay, Mr. Odler, I'm giving you this opportunity to address the committee if you so wish.
I have nothing really to add to what Mr. Walsgrove has said, except on the cleanliness of the outside of the premises. I noticed it the other day myself. With the rainfall that we've had, the moss has grown. Generally, it's cleaned, and it will be done within the next 7 days. I'll have it completely washed, power washed, and every bit of debris will be removed as I say, in the next 7 days.
Okay, Mr. Roger, thank you for your assurance. I will now move on to right. The next on the list is the objectors. First of all, I have Councillor Northover. Councillor Northover, would you be happy to address the committee, please?
Yeah, is this to make a deputation, or am I asking questions of the applicant?
Just bear with me one moment. Yes, you're welcome to ask any questions of the applicant if you so wish. Councillor Northover.
Can I just address the committee? Because I do have to go quite soon. Is this the spot where I would just address the committee?
Yes, indeed.
Okay, great. Okay. Okay, so I've made an objection. I think the area is totally unsuitable for this kind of premises. And a lot of the reasons are actually the reasons that the applicant is saying that they think it's suitable, because I think being in the heart of the nighttime economy, where there's a huge number of very vulnerable young people, young women, is actually what does make it unsuitable. And when we talk about what the club can do to mitigate against the issues that I'm concerned about, I think there is actually very little that they can do, because the sort of scenario I have the concern about is where people go to the club, they usually go there very late at night, they're drinking, obviously, and they're spending a significant amount of money on asking women to dance for them or whatever, take their clothes off. And when they come out of there, they're frustrated. And the next thing, they're out in the middle of Old Christchurch Road with a huge number of all different sorts of people. A lot of people are intoxicated and they're away from the club. So none of this is ever going to be picked up by the police, but women get comments, they have sexual, there's assaults that are happening, loads of assaults around that area. It's like a hot spot, and it is at 2-3 in the morning that these sorts of things happen. And I can't see how we can have a club like that in a place where we've got such a significant problem with violent and sexual assaults right in that area. And I can't really see anything that the club could do. I'm not criticising the club in how it operates, because I can't see how they can have any control over what people do when they leave. But I've been in the club, I've spoken to men in there, and I know that the attitude is that they would like to do more than what they're allowed to in that club. They would like, the man I spoke to would like to be able to slap women, bite their nipples. This is what he said. I've had offensive comments to me by men that have come directly out of there into another club at like 2 in the morning. So I know that it happens. I can't really see how it can be mitigated, and I can't see how we can achieve our equality responsibilities when you've got a place that is going to cause women to feel they can't be feeling safe in the vicinity of that area. I just can't see how these two things can work together. So I think the area is completely unsuitable. I can't see how it can be mitigated. And let me just check if I've got anything else. I can't see how we can rely on the police to be able to tell us, because they will only ever be able to report to you as a committee about crimes that have happened inside the premises. And I'm not talking about those, that's nothing really to do with the concerns that I have. I had a little look at the website yesterday, and I think there is a danger that is acknowledged, because their own dancers are always escorted to their taxi afterwards. So there's an understanding that women leaving are vulnerable to men who have been in there approaching them. But so we're all women. So what about another woman who is just happened to be walking past at that time? Where's her protection? In the code of conduct, customers must abide by our strict code of conduct. Otherwise, they will be asked to leave the premises. Leave the premises into a huge number of young women who have had lots to drink, possibly just arrived in Bournemouth, start of a new thing. They're not expecting to have a man approach them who's been in a club for 3 hours spending hundreds of pounds. And let me see if I've covered everything. I was going to say about responsible advertising. They say that they have a brand that evokes class and sophistication, which I don't think the logo outside does at all. So I think, if anything, please get rid of that. But yeah, I think that's all of my comments. Thank you.
Thank you, Councillor Northover, for your contribution. Do members have any questions for the councillor at all? No questions. Thank you. I'd now like to call on Ms Stockwell, please, to address the committee. Thank you.
Thank you. Thank you, Mr. Chair. I'd just like to point out, having heard the legal advisor for the applicant, that it was my understanding that there is actually a pre-hearing process whereby the points which he's ambushed me on and ambushed you on, criticising my objection, can be discussed and the whole issue resolved with the information that he asked for. And I would have been more than happy to do that if we hadn't had this springing it on me at the last minute with a view to catching me on the hop, I should imagine. So that could have saved.
Can I just stop you there?
Yes.
Stop. Well, I'll refer to the our legal representative just to put us straight on that.
Yeah, there's no pre-hearing protocol for licensing matters.
I understood that if there was some problem, that there was informally, there was some if there was a problem in the objection, that the applicant could have informal negotiations going in via the licensing staff to try and resolve that. And certainly all those points that he's raised, I would have been more than happy to answer, but not at the last minute on an ambush.
Well,
Sarah, would you like to address the committee, please?
We certainly encourage mediation
Yes,
under Licensing Act issues when representations are made to licensed premises applications. We certainly encourage the mediation to discuss things, but that's entirely down to the applicant and the objector. But
exactly,
the problem was you wanted to be anonymous, so I couldn't pass your details to Mr. Walsgrove for him to be able to contact you.
I see. I didn't realise that anonymity would mean that mediation couldn't go on. So
Just that explains the situation.
yes, it does. So on the point, the suggestion that nobody has ever questioned the suitability of the applicant, last year I questioned the suitability of the applicant, but unfortunately my objection was out of time, and that was also on the HMO issue. There is floating around on the internet regarding the Portsmouth application, which I'm certainly not going to repeat because it's highly libelous, another witness questioning suitability at that point. Again, I can't repeat that because it's really not on. And also, I believe that the police and your own officer questioned the suitability in 2013 when they made objections to the licensing at that point. You've already seen in my written objection that I've anticipated that you will be brought back to the issues of change in the area. There's absolutely no legal requirement that the area has to be changed at all in the last 12 months. That was a policy that's now been quashed. So the attempt to lead you into believing that, I mean, changes are significant, of course, but they are not the last word. The fact that a previous committee has licensed this establishment doesn't mean that you can't still look at the character of the area, whether or not it's changed. And I think that's the end of my address to you. Thank you. And thank you for the opportunity.
Thank you, Ms Stockwell. Do members have any questions at all from Ms Stockwell? No. Okay, so in the summing up process then, can I just ask Ms Stockwell if there is anything else that you'd like to address the committee with that you may have forgotten?
There was just one thing that I did make a mistake in my objection when I was reading it through last night. I said that I'd been living in Bournemouth for 30 years and actually I've been living in Poole. Okay. I just wanted to say that in case
Okay,
But
thank you
everything
very
else
much.
is,
Thank you for that
I stand by.
clarification. Right, just to confirm then, Councillor Northover, are you still with us?
Hi, yes, I am.
Is there anything else you wish to address the committee with that you may have forgotten in your
Yeah.
address?
Yeah,
Thank you.
I just actually wanted to say about the lack of objections, and just to point out to the committee how, for one, it's very difficult to know about these applications. I think, I mean, you'd have to be really sort of into it to be monitoring all the time. If you want to look at current licenses that are going to be coming up, I just ask you to try this yourself. Go to the front page of the BCP website and actually try and get to current licensing applications. I'm pretty familiar with it. I get lost all the time on there. At one time you could see all of the licenses as well, which you can't now. Even when you do inquire, all you get back is the front sheet that you see on the lamppost. You don't get back the license itself. It's very difficult to know what is really going on. And also, as in my experience, having objected to a few of these licenses, it's you get a lot of very unpleasant online comments. The Echo more recently has turned off comments, but before, I wouldn't even probably encourage people to object, because you're going to get it, and it's very I can't see why anybody would really want to. You can put in for anonymity, but I don't think that's obvious, and so I think a lot of people would be really put off. So I don't think it's really fair to say there's not been objections on that basis. Thank you.
Thank you, Councillor. The only thing I would say that I regularly get updates from officers with regards to licensing applications. So out of this meeting, I will have a chat with Sarah just to check and make sure that you're included on those email updates.
Okay, I get the list, but then when you have to ask for further detail, I think if you're a member of the public, you wouldn't really even know what you're asking for.
Okay, as I said, I'll have a chat with the licensing officer outside of the meeting to discuss that. Mr. Wargrove, did you wish to sum up at all?
Yes, please, Chair.
Is there anything that that you may have missed that you just want the committee to be aware of?
Yeah, just a couple of points, basically on the observations of the objectors just made. In relation to objections, it's not the case that people have to wait until a renewal application is made. If there were concerns about the safety of young persons in this locality, both the academy and the university would have been approaching either the police, the local authority, or indeed the owners of these premises. It's not right to just simply say, oh, it's so difficult to find an advertising of a renewal application. You can attach weight to the fact there aren't any objections, because we know that concerns aren't being raised by the local community. The academy is not speaking to the police or council saying, well, the young women at our academy are having difficulties. So it's definitely wrong to say, well, people don't object because they can't find the application. There's plenty of ways in which concerns could be raised. I think in terms of the change of locality, it is absolutely right, and I certainly didn't say that if there's been no change, you can't refuse the application. We all know you've got a complete discretion in an application to renew a sexual entertainment venue licence. So I'm not, and didn't suggest that if there's no change in the locality, you're bound to grant it. What I'm saying is you have to attach weight to that fact. You do have to attach weight to the fact that this subcommittee last year granted the renewal of the licence for 12 months, and that in the following 12 months there has been in our submission no change in the locality. So it's about attaching weight. It's not saying it's a hard and fast rule that if there's no change, you have to grant it. I accept that entirely. And I think that's important to make clear so that both those who are objecting and you as the panel know the legal basis on which you approach your decision.
Your point is well made, Mr. Walker.
My final point is I didn't get an opportunity to ask questions, not that I would have done, only other one, which was we need to know who it was that was lobbying the committee, whether it was the councillor or the anonymous objector.
What I would suggest is that you write into the licensing officer or Linda Cole just to check and make sure with regards to that. Okay.
Yeah, thank you.
Thank you very much. Okay, I will now conclude the hearing. At the end of this meeting, the subcommittee will adjourn in private with the legal advisor and the clerk to deliberate. Notification of the subcommittee's decision will be provided within the period of 5 working days, beginning with the day or the last day on which the hearing was held in accordance with the regulations. The notification of decision will include information about the right of appeal as appropriate. I would just ask the legal advisor just to confirm the appeal process, and then I will finally close the meeting. Mrs. Cole?
Thank you. There is a right of appeal to the decision that's made today. Details of that will be in the decision letter, and any appeal is made to Dorset Magistrates Court within 21 days.
Thank you, Mrs. Cole. I now conclude the meeting, and all parties are free to leave. Thank you.